intro. Thanks. Okay, everybody. Hi, I'm Alexis. I've known Alyssa a long time, actually, many years now. And I'm really excited to be here with PHP tonight. The first thing I want to say is I always start off by saying this is a process, a legal process through the court that we're going to be discussing tonight, but you do not need to have an attorney to do this process. This is something you can do yourself, or you can do it with the help of an attorney. And my job here tonight is to teach you what is conservatorship, why is it necessary for some families, and then talk through the process of setting one up. And I'm going to give you lots of information and resources. So whether you're going to take this on yourself or work with an attorney, this is all information you're going to need about how this process works. Pretty much 90% of my practice at this point is focusing on this specific type of conservatorship. I've done it in, I think, 12 counties at this point. So this is a California-wide system. I'm sure there are people from all various counties here tonight. And so I'll be pointing out like little tiny differences that happen in different courts, but overall, this is a statewide system that applies to everybody in California. I am going to try sharing my screen. Let's see what happens here. All right. I am just going to look out if anyone is here with their face and can give me a thumbs up, or Alyssa, you can tell me that this is working.
We're looking good.
Great. Okay. Thank you. All right. So, there we go. Okay, so let's start at the very beginning. Oh, and I'm just going to say, people can put their questions in the chat box. And at the end, I'm going to go through the information, and then at the end, I will be here as long as needed to answer questions. So, and you are welcome to put your question in the chat box along the way so that your question doesn't get lost or forgotten. Here we go. So conservatorship. Let's start with just the very basic. What is conservatorship? Conservatorship was in the news a lot recently due to Britney Spears. Many of you may have known. And the idea behind conservatorship, although Britney's was a totally messed up situation, is the idea behind it is you have an individual who is an adult. In California, that means someone who is 18 or over. So you have an adult that is unable to provide for their own needs for things like food, clothing, shelter, managing their own finances. Okay. If they need a lot of assistance with those things, then they are technically eligible for conservatorship. And a judge is going to appoint somebody called a conservator who is going to oversee and make sure that the individual's needs are being met. Okay, so we're going to be using two terms here a lot tonight: conservator, which means the person who is in charge of managing the care for that person, and the conservatee, who is the person that needs the assistance. All right, now within conservatorship, there are two kinds, there are actually multiple kinds, but the two main kinds are a general conservatorship and a limited conservatorship. Now, we are focusing tonight specifically on a limited conservatorship, which applies to individuals with developmental disabilities. In California, they have carved out a specific law around conservatorship for individuals with developmental disabilities. Okay, now I usually say it's called a limited conservatorship because, as we'll see soon, the law has specific decision-making authorities that you can be granted as conservator. Okay, and the court is going to go through all the options of what decisions can be made and decide which ones are appropriate for your case. And so it's limited to the decisions that are needed for this specific individual. Okay. So within the conservatorship, there's a conservatorship of the person and of the estate. All right, so of the person would mean you are making decisions about their personal care, such as where do they live? What type of education are they receiving? What type of medical treatment are they receiving? Okay, those types of day-to-day personal care decisions. A conservatorship of the estate means that you're managing their finances. All right, now you can have one or the other or both. All right, now in this presentation tonight, we're really going to be mostly focusing on conservatorship of the person. In the majority of the cases that I handle, the individual being conserved doesn't have money to be managed. They may receive public benefits. A lot of times when an individual turns 18, they become eligible for SSI or SSDI, for instance. But those benefits can be managed outside of a conservatorship. And if you look here, it says you can be a representative payee of those benefits. And I've given you a website that you can look at to check out that information about being a representative payee. So if it's only a public benefits management situation, you don't need a conservatorship of the estate. If there's something different, like the individual inherited money in their name, or, a parent set up some sort of account back when they were young, and now at age 18, they're going to have access to it or something like that, that's a different matter. And then a conservatorship of the estate may be necessary. But most of the time, the individual doesn't have any assets in their name. And so it's really just a conservatorship of the person situation. And that's what we're going to focus on tonight. So let's, the $1 million question, do you need a conservatorship? Okay. And what are the alternatives to conservatorship? So this is obviously not a question that I can just sit here and give you a black and white answer to. Instead, what I can do is talk you through some scenarios that come up for parents, some roadblocks, let's say. Now, the first thing to understand, as I said already, is conservatorship applies to an adult. Okay. You can't conserve someone who's not an adult because they're still a minor and they are still under basically the decision-making authority of their parent until they're 18. So do you need a conservatorship? Well, are they still a minor? Then no. But are they turning 18 or are they over 18? That's when you're going to start thinking about this. Conservatorship is going to grant you the ability to make decisions for your child. I'm going to use the term your child throughout this just for simplicity reasons. I understand there are probably plenty of people here tonight that you're not here for your own child, but we're going to do that for simplicity sake. So the idea behind conservatorship is granting you decision-making authority for your adult child, because technically when that child turns 18, those are their decisions to make now. Are they going to get a COVID vaccine? Are they going to say, yes, I want this surgery I need? Are they going to, live in this group home that you are encouraging them to live in? Are they going to go to this school programming that you want them to go to? Those are their decisions to make once they turn 18. Okay. Now, if you want to be the one who's sitting in on those meetings and advocating and signing off on the paperwork that is necessary to, get them access to these opportunities that you want, that is when having a conservatorship can come into play. All right. Extreme examples I've seen, and I'm not saying this is common. I'm not saying I see this all the time, but extreme examples that come into play can involve medical decisions. For instance, I had a client whose daughter was, 30 in her early 30s, but had the cognitive functioning of, like a preschooler and couldn't understand, the implications of the surgery that she required. Now, the hospital needed to perform, and it was a basic cataract surgery, so she'd be able to see. And this hospital said, well, she can't consent to this surgery. She doesn't have capacity to consent. But you can't consent, they said to the parents, because she's an adult. And so you don't have the right to consent for her. And so they were just like stuck in this gray area until they got a conservatorship in place and could consent to the surgery for her. All right. So medical treatment is a common one that I see. Or just as simple as being able to be in the room with the individual and talking to the doctor on their behalf and collecting medical information. Other examples, when you're working with the regional center, for instance, and deciding, vendors that you're going to use. I had a client whose daughter was living in an apartment with supported living services through a local agency, and just truthfully was not getting great care. There was many things that could have been better. And they wanted to switch to a different agency through the regional center. But this individual was very resistant to change and did not want, a new staff coming in. And even though things were happening like broken glasses, so she couldn't see for 3 weeks, very like things like that. So the parents were stuck because the regional center said, well, she's our client and she doesn't want to change vendors. So we have to, go with her wishes. And it wasn't until they got a conservatorship in place that they could then switch vendors, bring in better care for her, and things got better. So it's those types of roadblocks that parents hit that require a conservatorship. Let's talk about what the alternatives are. Now, the basic alternative is legal paperwork. So, a lot of you may have a power of attorney or a healthcare directive that you have signed as part of like your estate plan or whatever it is, where you say, if I can't make my own medical decisions, I, am nominating so-and-so as my agent. Or a power of attorney over your finances. If I can't manage my finances, so-and-so is my agent to do so. Those are legal documents that an individual can sign to pass over authority to somebody else. So, having a healthcare directive that your child signs that says, my mom can make medical decisions for me, that is an option. Power of attorney over finances. Again, most of these kids don't have finances to manage, so that doesn't come into play so often. And then a release of information, which is just a very basic form where the child can sign and say, I, give my mom the ability to access my private records with the regional center, for instance, or with my school, or whatever agency or organization it is. Now, it's important to understand that a release of information doesn't give you decision-making authority. It just gets you access to information that is technically confidential once the individual turns 18. Now, there's also, so let's go back now. Those are all legal documents someone can sign. Two things to take into account here. Number one, is the individual capable of signing a legal document? Do they understand what there's, this is so embarrassing. My cat has decided to join. Now I'm the crazy cat lady. Two things to keep in mind. Is the individual capable of signing a legal document? Do they understand what they're signing? Because if not, then technically speaking, that's not a valid legal document. The second thing to take into account is, let's say they are capable of signing a legal document and they understand what they're doing. That is not a permanent situation. If they are have volatile nature, for instance, one day they agree and they say, yeah, this is great if you want to make these decisions for me. And the next day they say, no, I don't want you making these decisions for me. Then that paperwork basically it's no longer valid once they've decided that they don't want it to be valid anymore. So those are some of the issues with signed documents. Also, you can't really sign over decision-making authority, except for the healthcare directive, where you can say, I am letting my mom make medical decisions for me now. But otherwise, you can't really sign off your decision-making authority. Now, there is something called supported decision-making. It is, I'd say, a new kind of up-and-coming concept. It is actually codified into law in some states. California, it is not. The idea behind it, but it is in the works in California. The idea behind it is creating a team. The individual gets to create their own team of individuals who will help them make decisions. Now, it doesn't place decision-making authority into the hands of those people, but it allows them to be part of the team that sits in on meetings and helps guide the individual into good decisions, okay? If you go to the ACLU's website, for instance, they actually have a whole area about supported decision-making that you can check out. And again, California doesn't have this in law yet, but that is in the works. And I would expect something to come out of it in, I don't know, maybe the next few years. So something to keep an eye out for. Now, if you decide that conservatorship is right for you and you need to move forward with it, what do you need to prove? What is the standard of proof that you need to show to the court? Well, it's a very broad standard, quite honestly. Is the individual able to provide for their own needs for food, clothing, shelter, and physical health? Can they do that without, on their own and completely independently, or do they need a lot of assistance with that? If they need a lot of assistance, then technically they're eligible for a conservatorship. Now, conservatorship of the estate, you would just need to prove that they are unable to manage their own finances or that they're subject to undue influence or fraud. So these are, pretty broad standards we're talking here. And within the process that you'll go through and the paperwork you'll go through that you'll submit to the court, you'll have the opportunity to write out a description of the individual to explain, what they can do for themselves and what they cannot do for themselves and what they need help with. Now, this is what the California law allows you to request regarding decisions that you can make. So there are 7 within the law decisions that you can request to make on behalf of the individual, deciding where they live, having access to their confidential records, entering into contracts on their behalf, consenting to medical treatment, making decisions about their education. And then there are 2 that are a little bit controversial, and we'll talk about them more a little bit later on, but those are controlling their social and sexual relationships and consenting or withholding consent to marriage. So these are the 7 that the law allows you to request, and you can request all 7. You can just request some. It's totally up to you and your specific situation, what you're going to request. Oh, okay, there we go. Now, very important to understand, a conservatorship, the idea behind a conservatorship is, yes, it is placing decision-making rights for an adult into someone else's hands, okay? So courts obviously take this very seriously. They do not want to, the idea behind a conservatorship is the individual who is placed in charge, the conservator, is supposed to be doing everything they can so that this individual has access to support and services that will help them see their maximum potential of being able to function as independently as possible. So they don't want to see a parent who, is, how do I put this? They want to see a parent that is encouraging the individual to be participating in programming, that is encouraging that independence, and that is not setting up roadblocks along the way for their child to be able to participate fully. So that's very important to understand. The idea is not you step in and now you get to make all the decisions. The idea is you will help guide the individual in making decisions, and you have the power to step in and advocate when necessary. Okay, that is the real idea behind conservatorship. Now, who acts as conservator? A lot of times it's a family member, obviously. A lot of time parents can act as co-conservators together. That means that they will share decision-making authority 50-50, okay? Or siblings, okay? Or a parent with a sibling, whatever it looks like, it's going to vary family to family. But it is important to understand that if you have co-conservators, you have more than one conservator, those people share the decision-making equally. So they have to agree on decisions. A lot of people at this point ask, well, about what happens when I can't be conservator anymore. I'll talk about down the road later on. So we'll get to that. Right now, we're just going to talk about the here and now of who can act as a conservator. Another thing important that I like to point out, a lot of people say, well, can I do myself and my spouse and, the siblings, and can we just all be conservators together? And, some attorneys kind of have a hard rule that they'll say, I won't do more than X conservators. Some courts will even do that. But the important thing to understand is if you are, let's just give an extreme example, in the emergency room and need to make a decision and you hand over paperwork that shows, 3 names on it of people who are conservators, is it possible that doctor will say, well, I need all 3 people to consent to this type of thing, right? So that's something to keep in mind. Now, does that happen all the time? No. Do I have clients calling me, telling me that, they've hit this block because they need everybody present all the time? No, but at the end of the day, it's very dependent on whoever you're handing that paperwork to. And there are things like the regional center or IEP meetings where a lot of times all conservators do need to be present at those meetings. So that's something to keep in mind when you're deciding who the conservator team is going to be. Okay. And yes, there are professionals who do this as well. All right. Now we're going to start moving into the process of setting up a conservatorship through the court. This slide just gives you an overview of the whole process, but we're actually going to be going into detail in each area. And, the very beginning of this process is paperwork, a lot of paperwork and filing a petition. And then the end outcome is a hearing where a judge decides whether or not to put the conservatorship into place. All right. So let's talk about what that looks like. Now, I always say clients should start I feel like I'm going to sneeze. Excuse me. Okay, so I always tell clients that they should start with something called the capacity declaration before they even start touching looking at the paperwork they need to do. What a capacity declaration is, it's a required form during the conservatorship process. And this form needs to be completed by one of the individual's treating doctors, okay? It needs to be a California licensed MD. So that can mean a neuropsych, that can mean their general physician, that can mean as long as they are a California licensed MD, that person can fill out this paperwork. Also DO, I should say as well. This is a form, and I'm going to tell you soon how you access all these forms and find them. This is a form you can find online. You can Google it right now if you want, Capacity Declaration GC 335, and take a look at it. It is a required form that a doctor needs to complete. The idea of the form is the doctor is going to be commenting on whether the individual has capacity to give informed consent to medical treatment or does not have capacity to do that. Because one of the things you're requesting is the ability to make medical decisions for this person. So you need a doctor to state that this is necessary because the individual can't make their own medical decisions. The form is basically it's late, give me a second here. It's basically a scale from no impairment to severe impairment that they check somewhere on the scale of various cognitive functionings, such as short-term memory and long-term memory and, abstract thinking and alertness. Do they know what day of the week it is and all that, those kinds of, so it's a various mental functionings that they are commenting on. And you want them to support your case by marking that there are some impairments. And then at the end of the form, checking the box that says the individual lacks the capacity to give informed consent to medical treatment. Okay. Now, I always start here because if you don't have a doctor that's going to support your case by filling out this form in a way that supports your case, then you don't want to move forward. So I always tell clients to make sure first that the doctor is going to fill this out for them and complete this paperwork. Okay, so this is your first step. Something else to note is on this form, doctors can also indicate if the individual is able to attend the hearing. And we'll talk about the hearing later on and attendance of at the hearing and all of that. Okay. All right. So now, you've spoken to the doctor, they're supporting this, they're going to fill out your paperwork. Now you can really hit the harder paperwork. But let's just talk about what this even, let's get the background first and see where we're going here. Where do you file a petition for a conservatorship? Well, you do it in the county where the individual who needs assistance, where they live. So if they live in a different county from you, you're doing this in their county, okay, and the local court of their county. In the local court systems, they have all, they have family law, they have, small claims court, all these different areas of law. The probate department is the one that handles conservatorships. They also handle wills and trusts when someone dies, for instance, and they handle conservatorships. So that is who's going to handle this case, the probate department of the local court where the individual lives. All right. Now, when can a conservatorship go into place? Like I said, a conservatorship can only happen if the individual is an adult. Okay. So that means they need to be 18 or over. So you can do it anytime once they've turned 18. I'm doing a conservatorship right now for a gentleman in his 60s. So it can happen at any time in their life. As far as some parents, are concerned and want it to be in effect once the individual turns 18. And you can do that also. You can do this in advance of their 18th birthday, so it goes into effect on their 18th birthday. Now, the timeline of that will look like having the hearing right around the 18th birthday. And that means starting the process a certain number of months before the 18th birthday. And that honestly varies county to county. Like Sonoma County, for instance, which is the most efficient court that I work with, if I give them paperwork, we'll have a hearing 6 weeks later. It's pretty incredible. Other courts, Alameda, for instance, San Mateo County, those courts are going to be more like 4 to 5 months later. So it totally depends on the county that you're in as far as how you want to timeline this. Okay. And then how much does this cost? So if you're going to handle this yourself, and so you're not thinking about attorney's fees or anything, there are court fees involved with this. There's a fee just to file your documents, and that ranges from $435 to $465, depending on your county. And there's a second, which is a court investigator fee. And we're going to talk about what a court investigator is in a little bit. So you're looking at, depending on your county, you're looking at roughly, let's say, $900 to $1,300 of fees, depending on your county, because the fees vary. Now, the good news is most people are eligible for a fee waiver. Oh, there we go. Fee waivers are, for low income, indigent, as the court says, individuals that can't afford fees. Well, fee waivers in conservatorship cases are based on the person being conserved's income, not on your income as the person, bringing this into court. So if the individual doesn't have any income or receives SSI or Medi-Cal or IHSS, those are all things that automatically get fees waived. So there's a form that you would fill out, this form right here, the request to waive court fees, that you would fill out, as well as giving the court an order that they could then sign and issue. And that means you do not pay fees for your case. Okay, so that's really important. One quick thing to note, if the individual has a trust or of any sort, a special needs trust, for instance, that currently has money in it, not a special needs trust that you've set up for once you die to be funded, a trust that is right now has money in it for their benefit. You do have to declare that on the fee waiver form. And sometimes that could mean that this fee waiver won't be granted because there is money available for the individual's needs. It honestly is a very court by court thing. So just want to put that out there. Now, this is a list of most of the documents, like the real main meaty documents that are required in a conservatorship case. And again, this is a California statewide system. So these forms are going to be required in any county court you're in. Now, all of these forms are available online, which is great. The easiest way to find them, honestly, is just to Google the name of the form and the number that I've put next to it, and they'll pop right up, okay? Now, I'm not going to go through all of these on this list because a lot of them we're going to actually talk about in detail in a moment, but this is, this is like the real place you're going to want to start in checking out these forms. Let's see, is there anything? Oh, and I should also state, these are the forms required, across the state, but each county a lot of times has their own forms on their own court website. Not all of them. I'm trying to think if there are any though. Yeah, I mean, most of them do. Most of them in the Bay Area, I should say. So you're also going to need to check out your court's website and see if there are fees available. I mean, forms that are required. Now, that can be a little overwhelming. You can either just call the court and talk to the probate department and ask them. You can also email me, honestly, and I can just send you in the right direction pretty easily. Okay. So So the way you've kicked off your case is you have filed this petition that is listed here and some of these other documents that are required. You've put all your paperwork together. You've taken it to the courthouse. You have filed it with the probate department, and they have now filed everything and given you a hearing date. Okay. And now you're on your way. Now, I also want to say these documents, like I said, they're online. It's a lot of check boxes kind of documents. And there is some areas where you do need to write in, descriptions of the individual, for instance, and their needs. Okay, so now you've done that, you've given your paperwork and you have a hearing date and your case is open. Where do we go from here? You do need to notify certain people that this hearing is taking place. There's a document called a notice of hearing that just says you have filed this petition asking for conservatorship, and there's going to be a hearing at this court on this date at this time. And you have to send that out to certain people. Okay, it's required by law. You send out your notice of hearing with a copy of the petition that you filed to the parents of the individual being conserved, unless that's you. You don't need to send it to yourself. Siblings of the individual, living grandparents of the individual. All those relatives need to receive a copy of the notice of hearing and a copy of the petition. Now, even if they live out of the country, you need to mail this to them. Also, the regional center, you are required by law to notify the regional center via mail. And the individual is going to be represented by their own attorney. That's a requirement that we'll talk about further in a moment. Right now, what you need to know is sometimes that attorney is from the county public defender's office. Okay. To throw out some examples, Marin, Sonoma, Alameda, Solano. Okay, well, there's a lot of counties that they have a public defender, someone from the public defender's office that represents the individual. And you can ask your court and say, is a public defender going to represent my child? If the answer is yes, you are required then to mail a copy of the notice of hearing and the petition to the public defender's office, which you can just Google and get the address and mail it to them. It doesn't have to be to a specific person. They'll get it to the right place. Okay. Some individuals, some counties have a panel of private attorneys, we say. For instance, it's someone like me. I've served on San Francisco's, I've served on Marin's. It's an attorney like me that handles a lot of conservatorship cases and that agrees to serve on this panel, and the court will appoint someone from the panel to help out. So if that's the case, if it's a private attorney, that's not your responsibility to send them this information because the court is going to take care of that. Okay. We will talk about the regional center in a moment. I just want to say I always suggest as soon as you've filed everything, getting in touch with your regional center case manager and letting them know that you have filed this and letting them know the hearing date, because they have a requirement of something they need to do. And so in order for them to have enough time to do it, it's really important that you let them know immediately. Okay. So, all right, let's keep going. Next step is something called a citation. I'm going to go through this one quickly. This is basically paperwork that needs to be served on the individual. Okay. Actually personally served, the whole, you've been served thing. So you have to have somebody who is going to walk up to the individual and hand them paperwork. And that person who's done that, who's handed them that paperwork, then has a form they need to fill out stating where and when they did that. I should also state that with the notice of hearing we just talked about mailing out everything, you need to have someone other than you mail that all out. You're not allowed to mail it. You have to have someone else drop it in the mail for you. And then that person who dropped it in the mail, there's a form they fill out that they're, under penalty of perjury, I mailed all this on this date. Okay. So these are just ways that people are getting notified that this hearing is taking place. All right, let's talk about the attorney that's going to represent the individual being conserved. Like I said, it's either going to be an individual from the public defender's office in the county, or it's going to be a private counsel, someone like me. Okay. Now, people don't love attorneys. I don't love attorneys. I'm an attorney, but I get it. Like some attorneys suck. So people get very weird about knowing that their child is going to be represented by an attorney, and it causes understandable anxiety. Because attorneys are thought of as very adversarial, right? And that is not what this process is like. Okay. And that's why I do this for a living, because I don't want to be part of that adversarial process. So the idea behind the attorney that's representing the individual is they are supposed to meet them and they are supposed to try to engage them in a conversation. Now, obviously, individuals that are being conserved vary so dramatically in their abilities, right? There are nonverbal all the way up to high, very verbal, verbal processing abilities vary, so the attorney's job is to try to engage them in a conversation and determine, does the individual understand what this conservatorship process is? And do they understand that, these decisions are, that your mom or whoever it is that is asking to make these decisions for you? And they're supposed to try to gauge, do they understand this? And do they have an opinion about it? Okay. So they are supposed to visit them. Obviously during COVID, things got thrown totally out of whack and everything was being done remotely. And there's a shift back now into more in-person with these things. It still varies county to county. It still varies depending on, does that person, were they exposed to COVID recently, or do they have COVID right now, or whatever it is. So it totally varies. But the idea is that they should go see them in person and have a conversation with them. And then their job is to represent that to the court. And that might be the attorney saying to the court, I couldn't determine an opinion, but, I don't have any objections to this. Or it could be, I spoke to them and they don't have any objections. They support this, it just varies on the case. In some counties, they'll actually even write up a report and file it with the court, and you would get a copy of that ahead of time, just stating about their meeting and their opinion. Okay. But most important thing I really want you to understand is that this doesn't have to be an adversarial situation, and that these attorneys are very used to these cases and understanding of the fact that you are trying to do what is the best interest of your child and being able to protect them when they need it. Okay. Now the regional center, like I said, is involved in this. They're required by law to prepare a report for the court about their recommendation. Okay. So they are supposed to, let's say you've requested all 7 of the powers you can request within a conservatorship. Their job is to go through each of those powers and make a recommendation to the court. So they say, we think the power to fix the residence should be granted to the conservator. Okay. And we think the power to, have access to their confidential records should be granted to the conservator. Now, I mentioned earlier that the powers regarding social sexual relationships and marriage are controversial. Those can be controversial. The regional center sometimes doesn't like to recommend those powers be granted. Now, obviously, there can be cases where it is necessary, where an individual has shown, has had a history of situations that show that they cannot make safe decisions around that. So if that is the case, I always recommend that clients bring that up to the regional center and address it ahead of time so that the regional center has that information when they're preparing this report. It's not a very black and white situation where I get reports of all kinds. Sometimes they support all the powers and sometimes they don't support those two. And it really varies, quite honestly. Now, what's really important to understand is the regional center's report is not binding on the court. The court does not have to go along with their recommendation. And this is also a county by county thing. Some judges give more weight to the regional center report than others, quite honestly. So it really varies. But this is, again, I just really want to say our regional center workers are underpaid, understaffed, under-resourced. It's a very tough system. And this is just another thing that they need to put on their to-do list. And so again, as soon as you know you have your filed documents in your hand, reach out to your case manager and let them know the hearing date and that this report is required so that they have enough time to get it done. Okay. And, a lot of times they're going to request a meeting with you. All right, let's see how we are on time. Okay, we're doing well. Great. We are right on target. And remember, I will stick around at the end. I see that there's some questions in the chat box. I love that. So I will stick around. We'll get through questions. So, and don't forget, like Alyssa said, there is a survey at the end, very simple. Please take it as soon as I'm finished. She's going to launch that for you. So now let's move on. Now the final part of this is someone called a court investigator. And that's an employee of the court whose job it is to investigate the case and then give information to the judge so the judge knows what's going on here. Okay. So this slide shows what the law says. Here's what the court investigator must do. I say what they're doing is twofold. They are deciding, is this individual eligible for conservatorship? Okay, that's number one. Number two, is the person asking to be conservator an appropriate person to serve in that role? Those are really the two main things they're trying to figure out. Okay, now how do they do that? They're going to interview various people. They're at the very least going to interview you, the person who wants to be conservator, and interview the person who's being conserved. Okay, that's the bare minimum. And ideally, they'll see the individual who's being conserved in their home environment. Do they live in a safe place? Do they have access to clean clothes and a bed and food? They want to see all of that. And then they're going to interview you as well as the person who wants to be conservator. They may interview other people, other family members. They may interview someone from, the individual school or day program. They pretty much always want to interview the regional center caseworker. Okay, so, but it really depends, county to county, case investigator to investigator. Some counties have more resources and more investigators available. Some have less. So it really varies. And then they're going to run a background check on you. In some of the paperwork that you do, you have to do some confidential paperwork where you give your driver's license and your social security number, and you answer questions about, like, have you been convicted of a felony and those types of things. So they are going to run a background check on you. And then what they do is they put together a big report and they talk about all the people they spoke to and what those people said. And then that gets filed with the court and you get a copy of that report ahead of time. Okay. So, and I just want to say, again, I've done this in 12 counties or so. The investigators are really lovely people. They truly are very nice people. They come into this situation really, for the most part, compassionately and friendly. And it's going to be similar when they speak to your child. It's going to be somewhat similar to what the attorney is doing. They're trying to gather, does the individual understand what this conservatorship means? Do they have an opinion about, this person making these decisions for them? So they're doing a similar thing with the individual that the attorney is doing, just so you know. Okay. Now you are leading up to the hearing, you have this report from the investigator, you have the report from the regional center, and then maybe a report from the attorney if you're in a county where that's done. And so going into the hearing, you have all this information and you know where things are heading. In an ideal world, you do all your paperwork correctly, all your interviews go well, and your hearing is just really a formality. Okay, that's the ideal here. So let's talk about that hearing. Before the hearing, there's certain things, the judge is going to sign an order and you are in charge of preparing that order for them and submitting it ahead of time. And then there's also something called letters of conservatorship. That's going to be your golden ticket you get at the end of this. And we'll talk about that, but you're going to want to have those prepared ahead of time. And then there's a video in many counties you need to watch, not all counties, but there is a video. You can Google it and watch it. It is super old. I'm going to guess like sometime in the 80s. There's a lot of shoulder pads and bad hairdos, and it's not very helpful, but it's like 24 minutes long. And some counties require you watch this video. And some counties even have their own local form that you have to sign stating that you've watched this video, like Marin, for instance. Okay. So that's something just to know, to have on your radar, that some counties require this video. Now, do you need to be at the hearing, and does your child need to be at the hearing? So yes, this says in most counties you're required to be. Pretty much across the board now, yes, okay? All counties are requiring it at this point. Now, does your child have to be at the hearing? That's a different question. You definitely have to be at the hearing, but your child doesn't necessarily have to be at the hearing. First, let's say hearings are via Zoom. You can do in-person or Zoom at this point, okay? I don't see an end in sight to the Zoom hearings at this point. There's been no murmurings of it. We all love it this way. It is very convenient, and it is a lot less stressful for the individual being conserved if they do need to attend the hearing, okay? So that's the first thing to know, is pretty much across the board, yes, you have to attend, maybe your child has to attend, and you can do it via Zoom. Now, how do we decide, who decides if your child needs to attend or not? That really comes down to your child and to their attorney, quite honestly. So both the court investigator and their attorney are going to ask them and say, do you want to be at the hearing? And they get to say yes or no. Okay, so that's number one. Number two is that capacity declaration that the doctor did. They get to, check a box that says if the individual can attend the hearing. So they could say no, for instance, because, the individual has such extreme anxiety or whatever it is. So that can also help if they say no. That doesn't excuse them, but that can be a factor to consider. The only person that can excuse their presence is their attorney. So if their attorney's met with them, has no issues with anything, and doesn't think that there will be value in the individual being there at the hearing, then that attorney can, at the hearing, say to the judge, I'm waiving their presence. I spoke with them. We have no objections to this. So that's up to their attorney, and that is something you would work out with their attorney ahead of time. Many of these attorneys understand that it is in the best interest of these kids to stick with their regular routine, to go to school that day, to go to their day program that day, whatever it is. Many of them understand that and are not going to require them to be there. But that's not the case in all counties, and some counties want the kid to be there, and the judge wants to see their face on Zoom camera. Okay. All right. So what happens at the hearing? Again, like I said, ideally everything leading up to this is smooth. You have all the information you need. Things are looking good. So what you're going to do is show up to the hearing. Important to understand, let's say you have a 9 a.m. hearing on a certain date. That doesn't mean that hearing, that 9 a.m. time is just for you. It's not just you and the judge. It is a few other people up to many other people, depending on how many people are on the calendar that day. So that's something to take into account, that it could take a chunk of time because you don't know if you're going to be first or in the middle or last. So you could be done very quickly, or you could have to sit there for quite a while other people are having their cases heard before yours. Okay. Now, it's going to be you. If you have an attorney, your attorney will be there with you, and then the attorney for the individual. Okay. Sometimes the judge may ask some questions. The attorneys generally do all the talking. And then, usually I've had hearings that are literally 30 seconds long, and the judge just signs the order and you are done. Okay. That's your ideal. Now, the big ticket, golden ticket paperwork you're trying to get here is called letters of conservatorship. That is the document you're going to show to the doctor and show to the regional center and show to their school, saying, I am conservator and these are the decisions I get to make. Okay. So this is the document that you need to have issued by the court once the order has been signed. You want to ask for a certified copy of this document. They're going to file it, and that's great, but you want them to also certify it, which is like an extra special stamp they put on it. And there is a fee to have it certified. But if you have that fee waiver on file that we talked about earlier, where all your fees are waived, you don't have to pay the fee to have it certified. Okay. All right. So after the hearing, I'm not going to go into great detail into this, but this is This is paperwork that's required once you have been appointed conservator. The first two, notice of conservatee's rights and determination of care, those are also accessible online like all the others, and they're pretty self-explanatory. And then many counties have something called a general plan. Marin has it, Alameda has it, San Mateo has it, San Francisco, like many counties have it. Sonoma does not. But the general plan is something that you fill out and file after the hearing is over. Okay. So this is something to understand, is just once your hearing's done, you still have a little bit more paperwork that's required. And then once that paperwork has been filed, you're in the clear. So how is this conservatorship maintained? This conservatorship lasts for your lifetime. As long as there is a conservator that is living and serving, then the conservatorship stays in place. So that's important, and we'll talk about how to prepare for the future. So the way that a conservatorship would end would be there is no conservator anymore, or it's not necessary anymore, which doesn't happen often, but can happen. The court is going to supervise this and visit, and they're supposed to do it after the first year and every 2 years thereafter. Some courts do it every year, and some courts don't have enough staff to keep up with the every other year. It totally varies county to county. But the investigator is supposed to come visit the individual, check on them, and just make sure and interview you, and just make sure things are going okay, and that the individual's needs are being provided for. Okay. And when they do that, they write out a report and you get a copy of it. And assuming everything is good with that report, nothing's required. That's it. Things to think about: if the individual moves, you need to notify the court. That's very important. If the individual moves out of county, then you should have your case moved from the county that they were in to the new county, assuming it's in California. You don't have to redo this process. You just have the case transferred over to the new county. And different courts have different procedures for that. If you move out of state, that is totally different. Conservatorship for individuals with developmental disabilities is a state-by-state system. Everyone has their own laws. Everyone has their own processes around this. In some counties, in some states, it's called guardianship. It's not even called conservatorship. So if the individual is moving out of state permanently, you are going to want to set up this conservatorship in the new state, because it doesn't transfer with the individual. Okay. And then last but not least, this is the last slide. You guys have made it. And then we're going to do questions. I want to say these first two topics I'm going to talk about are conservatorship related, and the last two are not. The first two, how do you prepare for down the road? You're not going to be able to be conservator forever. So you can nominate you have basically a few options. You can nominate a successor conservator in just a simple document. You can either write your own document, or in your will, when you're doing your estate planning, you can nominate, just like you would nominate a guardian for your minor children. If something were to happen to you, you can nominate a conservator for your adult child. Okay. So you would nominate somebody to take over once you can no longer do it. It's very important to understand that just because you've done that doesn't mean that, you walk outside, get hit by a bus, and now that person becomes conservator. That's not how it works. That person now goes to court, goes through a similar process to what we just discussed, and is appointed a conservator by the judge. And they have paperwork showing the judge that they were the intended person. Okay. So that's an option. Another option, some people will, for instance, I just helped a very, very, literally 94-year-old woman, a mother. She said, I'm 94, I'm not gonna be able to do this forever. So she went through the process to appoint someone to be co-conservator with her, so that it's already in place. And when something happens to her, there's already this other co-conservator in place. So that's an option of doing that also. Okay. Now let's just talk. I'm not going to go into these. These are workshops of their own, but I always feel like it's important to just put this out there so that you can do your due diligence in learning about these two topics. Preparing for down the road, you're going to leave any money to your child when you die. That inheritance should go to something called a special needs trust. A special needs trust protects that money, puts someone in charge of it, and also preserves the individual's public benefits. SSI is an income-based benefit, meaning if the individual has more than a certain amount of money, right now that's more than $2,000, which is a very low amount. If they have more than $2,000, they're not eligible to receive SSI. If the money is held in a special needs trust, that money doesn't count towards that $2,000 income limit. So it's a very brief explanation of it, something to look into, special needs trusts as part of your estate planning. And the second thing is our ABLE accounts. A lot of people, it's becoming more known, but a lot of people don't even know that ABLE accounts exist. This is a 529 account, like a college savings account, but this is a 529A account for individuals specifically with disabilities. It's a tax sheltered savings account that an individual with a disability can have a savings account up to a certain amount of money, $100,000, before they become no longer eligible for SSI. It doesn't work against that $2,000 limit. So this is a really great, Obama signed it into legislation. California just got their program of it up and running within the last, 2 or 3 years. So you can look it up. It's called CalAble. And that's just something I think is important for people to understand is out there. And then this is me. So I've thrown a lot of information at you tonight. First of all, I do these workshops quite often. It's always good. I literally had a woman the other day. I know her. She just attended it for her 4th time. So you can always attend another one because I feel like every time you get kind of a new layer of information out of it. If you go to my website, I usually have them listed of which ones are coming up. And so that's me. You can email me questions. I'm going to stick around and answer questions. And I will say, like Alyssa said, I do a lot of these, and I understand that hiring an attorney to do this is very expensive for some people. And so I set up this thing called DIY, do it yourself, limited conservatorship. It's a program, it's all online. It's videos of me going through every single detail of this process, including how to fill out every single form. So that is an option for those of you that are thinking of taking this on yourself. And I am going to stop talking. Whew.
Phew, get a glass of water.
Oh my gosh. How about a glass of wine or tequila or something?
All right. Well, thank you very much, Alexis. And we do have several questions in the chat. But before we get to them, if people can just direct your attention, if I can direct your attention to the chat, if you can click on that link and answer those 3 very brief questions, then that will help us with our funders. So I see people are doing it. 5, very good. We got a long way to go. We have 62 participants. 6, good. I'm going to start. I
already see a question on here that I'm like, I don't know what you're talking about. So, and I'm going to be very honest when someone asks me something. That's so funny. So Alyssa, should I scroll through these, or did you scroll and you kind of know some things that were asked that you want to call out, or how do you want to do this?
Yeah, I'm fine if you want to take a look at them. Why don't I just start asking you some, and you can kind of like scroll down with me. I'm back at the top now. Okay. And one of them is, can both parents be conservator of one child, which you answered in the
I did answer. I'll just answer once again really quickly because I know a lot of people jumped on like later. Yes, 2 parents can be co-conservators together. It just means that you are sharing equal decision-making rights. So each, it's 50-50 decision-making. You need to agree on decisions. That's the important part to understand about that. I see this question about AB 1663, the law that Newsom is signing into legislation about terminating conservatorships. This has come up because of Britney Spears. I am on